How you doing? My name's Edison Titus. I'm with the Titus Law Firm, and we're based out of Houston, Texas. We practice all over the great state of Texas. All right, so today we're talking about estate planning, right? What is estate planning, essentially? The point of this here video. And estate planning, in a nutshell, is the preparation of passing everything that you own to other folks after you pass away, right? So you are preparing to pass everything that you own to other people when you pass away, right? People of your choice. There are some parts of estate planning that are dealing with end of life issues, right? When you're maybe you get Alzheimer's or dementias, or you're not able to take care of yourself um, the way that you normally do, right? So those things are also in consideration. And so there's a group of documents, a bucket of documents that you would get after you finish your estate planning. So what are those documents, right? And what's their use? So we're going to save the will and the trust for last, right? We're going to start off with the financial power of attorney. So a financial power of attorney is a document that allows you to give somebody else the authority to handle your financial affairs without your involvement. They act as your agent. They have a fiduciary duty to you based off of that document, right? This could be for the buying of real estate, the selling of real estate. This could deal with any entity or entity ownership that you might have. This could deal with stocks and bonds and 401ks and life insurance. It can deal with the creation of your will, the destruction of your will. It could deal with pretty much anything that you deal with in your life can be put into a financial power of attorney. Now, this could be blanket. You can narrow it down to a certain thing, right? Just real estate or just the sale of 123 Main Street. Or you can make it super, super broad for everything, right? You can make it to where it only kicks into effect when you're incapacitated, or you can make it to where it's immediately in effect and they can do everything that you can do right now. However, it's important to note that financial powers of attorney do not have any power once you pass away. They're only good while you're alive. Next, we have your medical power of attorney. Medical power of attorney is just like a financial power of attorney, except it's talking about medical stuff, medical decisions, right? This is the thing that allows somebody else to make decisions for your health, right? When you're not physically or mentally able to do so. Well, really mentally. Now, that goes along with the HIPAA release. The HIPAA release allows that person who has your medical power of attorney to have the authority to talk to your doctors, your nurses, your healthcare providers, and to see your medical records. Because how are they going to make informed decisions about what you should or should not receive as treatment if they don't have access to your medical records and they can't talk to your doctors and nurses and whomever else about your medical status, right? Next, we have the physician's directive or directive to physician. This also is sometimes known as the DNR, the do not resuscitate. This is you letting everyone know, not just the physician, what your wish is in the event you're on life support or in the event that you're in a position to be resuscitated. Maybe you don't want to be resuscitated. Maybe you want to just let the end of your life come. And so you just don't want to be resuscitated. That's fine. Maybe you don't want to be on life support and have a tube down your throat, right? Whatever it is, you get to put it in that document so that way your wishes are heard and they're held by. Or you could palm it off and say, hey, I'm leaving it to my mom, my dad, my spouse to make that decision for me of whether I should be resuscitated or whether I should be kept on life support, right? Next is the designation of guardianship, right? Now, this is the designation of guardianship for yourself. Again, what if you're just fine, you get into a car wreck and now you're physically unable to take care of yourself, right? Or what if you have some sort of head trauma and now you're not the same person? You are mentally unable to take care of yourself. The the designation of guardian is essentially you saying, this is who I would like to take care of me in the event that I am no longer able to take care of myself. Then there's the designation of guardian for minor children, right? Or for minors, because children are minors, right? I guess not. You could be a child and an adult. So minor children, yeah. So it's the same thing as the what is it? Designation of guardian, right? But the difference is for your children. Upon your passing or your being unable to take care of your children, who would you like to take care of your children? Now, mind you, these aren't binding. This is you telling everyone, and primarily the courts, this is who I would like to take care of myself or my kids, right? As long as they agree and as long as there's nothing disqualifying them, I'm pretty sure that court would point them as guardian, right? Next would be agent for funeral matters. This is essentially the person who gets to make decisions regarding your funeral. The flowers, roses or hydrangeas, I think I pronounced that wrong. Let's go with daisies. Roses or daisies or oak or mahogany or whatever the case may be. That's the person who gets to make the decisions regarding your funeral, right? Then there's agent for remains, the person who makes decisions regarding your remains, the person who gets to take custody and who decides if there's an autopsy or not an autopsy or embalming, and they're the ones who are in charge of your body, right? Now, you get to say whether you want to be cremated or not, but let's assume that you didn't say, then it would be the agent for remains who gets to decide. Now, all of those documents together is your or are your estate planning. It's multiple documents, so that's plural. So I figure it would be R. But then estate planning as a whole is one singular thing. So I guess it is your estate planning. Y'all let me know in the comments. I'm not sure. All right, here's the thing. The last two things are your will and your trust. So do you need a will and a trust? That's the first question. No, you do not need a will and a trust. A will by itself is sufficient, right? And you could include in there a testamentary trust, which is a trust that doesn't come into being until after you pass away, right? But the idea here is that you need a will, you might need a trust, right? And there's different types of trust. There's special needs trusts, there's legacy trusts, there's a list, right? And then some people, they just want a trust. Why does this matter? A will is a document that doesn't come into effect until after you pass away, right? And it essentially you saying, hey, this is everything that I own, my estate, and these are the individuals who I want to give my estate to. I want to give this person $10. I want to give this person $5 million. I want to give this person property A, property B. I want to give this person my silverware, my video game collection, right? As granular as you would like it, or just, hey, I want to give everything 25% to each of my 4 children. You can give everything to the guy walking down the street, right? You can give it to whoever you want, right? That's the purpose of a will, right? Because when you pass away, that will needs to be probated. You take it to the court and people have a chance to challenge it if there's something worth challenging. And there's certain things you can put in there to dissuade people from challenging it, right? But whoever you leave behind, they're going to take that will to the probate courts in your county where you were domiciled, where you live, and they're going to probate it, right? And that gives direction. You appoint an executor or an executrix, and that is the individual that the court will then appoint to handle your estate, your stuff, maintain your estate, your stuff, until everything is dispersed to who it needs to go to. And then they close your estate, right? That's the purpose of a will. Now, a trust is a document that allows some of your stuff or all of your stuff, if you put it in the trust, to pass outside of probate. So that whole process with the will and going to court and the judge, all of that is a public process, meaning anybody can go online and they can see the will and the application for appointing the executor. And while they won't see everything in your estate, they'll see some specific highlighted things in your estate, right? And so it's a very public process, and not everyone is okay with that. Plus, the process takes time and money, right? Usually, the larger the estate, the more expensive the administration of your probate, right? Or appointing an executor and then distribution of assets. Now, if you have a trust, you can put stuff into that trust and it no longer belongs to you, right? And so what that means is that whatever you put into that trust is not a part of the probate process. A trust is a pseudo contract, pseudo entity type thing, right? It acts like an entity, LLC, C Corp, that sort of a thing. And it acts like a person. We'll get back to that. But a trust is its own creature, right? And whenever you take something from your personal estate, right, you have a car or a house, right, or ownership in an LLC, it's all in your name, and you move it into the name of the trust, right? ABC Trust. ABC Trust now owns it. ABC Trust now controls it, but because it's not a sentient person, sentient being, right, it needs someone to operate it. That's where the trustee comes in. So the trustee has control, but everything in the trust is for the benefit of the individuals who are named by the person who made the trust. So the person who made the trust is the settlor, right? So I can make the trust and then appoint John Doe as the trustee, and I can appoint my kids as the beneficiaries. So I'm the settlor, right? So everything that you put in there, the settlor makes the trust and says, hey, I'm putting this stuff in, and here's who's going to be the trustee. Here's who's going to be the beneficiaries. Now, 9 times out of 10, unless you're doing something very specific with a very narrow outcome that you want to see happen, you, the person who makes the trust, is also going to be the trustee, right? For the purposes of estate planning. I'm putting stuff into it. I'm the trustee. I cannot be the only beneficiary, right? That trust is not a trust, right? There's plenty of law that specifically states that trust is not a trust. It can easily be destroyed, right, by anyone from the outside. So that means that you have to have other beneficiaries. So you can create the trust, put the stuff in, and be the trustee, but you cannot be the only beneficiary. So that's where your spouse and your kids, your mom, your dad, your siblings, whomever, you need at least one other person to be a beneficiary, right? Now, at that point, it's now complete. You've got a trust, you've got stuff in it, but you've got your trustee, presumably yourself, and you've got beneficiaries more than just yourself. One day you pass away. That trust document should say, hey, when I pass away, control of this trust goes to this secondary trustee, right? And they must do these things. The trust will enumerate what they're supposed to do, right? Now, that process happens outside of probate. You don't need to go to court. You don't need to file anything publicly, right? That document controls all by itself, right? Whoever that named person is the person who's in control, right? You pass away, the death certificate is given, and essentially that's it. The person who's the trustee, they have the trust documents, the new trustee, that is. They have the trust documents. They've got the death certificate showing that you've passed away, right? The trustee document shows that you're the next in line trustee, right? whoever that person is, and now they have control, right? But they have a fiduciary duty to do what that document says for the benefit of the people who are the beneficiaries. All of this happens outside of the court and is not public, right? Now, that is the purpose of a trust, essentially, right? And assets can stay in there for a long time and it can be managed, and proceeds, income could be distributed, or the whole trust can be destroyed and everything's supposed to be given to all of the beneficiaries. Whatever it is that you want to see happen, it can be done in a trust, right? Now, commonly, you'll see people use these two things together, a will and a trust. The idea here, a very common thing, is that they'll say, hey, this is my will, this is my stuff, this is who I want it to go to. Anything that's not enumerated in here, I want it to pour over into my trust. And let's say that you did this will 5 years ago, and for some reason you didn't update your will, and you've amassed more real estate and stuff that's not spoken about in your will. There should be a clause in there that says, and my residual should go into my trust, essentially, right? Now everything goes into the trust after you probate, and anything that wasn't included in the estate is now in the trust, which has all your wishes of how you want things to be handled, divvied, whatever the case may be, right? Or you could specifically put certain things in the will and certain things in your trust, right? Or you could put absolutely nothing in your will and say that everything you've got needs to be going over into your trust. In that scenario, you don't need to have created a trust beforehand. You could just have a testamentary trust, which is created upon your passing away. So without getting into more of the weeds than I've already gotten, that is estate planning. You have that bucket of documents that each has its own purpose, and then you have a will and maybe a trust. That's it. Okay, the process, right? The process for estate planning is very consultative. You find your attorney, you talk to them. Once you feel comfortable with them, you hire them. After that, y'all are going to have a discussion, and he or she is going to ask you all the right questions. They're asking you about the extent of your estate. They're going to ask you about your marriage, your kids, your siblings, your parents, your in-laws, anybody else of any import, very close friends, that sort of a thing. And they're going to ask, who do you want to have what? We're going to go through all the if, ands, or buts. And then after that, the lawyer will run away into their corner and they'll write up everything that needs to be written up, right? They'll reduce everything to paper. After that's done, you have a little signing ceremony and you get everything signed, all your T's crossed, all your I's dotted. Then after that, your attorney should keep a copy, but the originals go to you. And they should advise you, do not put it in a safety deposit box, right? Because that creates a headache to get to the will after you pass away, assuming you're the only person who has access. They'll say, hey, keep it in your personal effects. Maybe you get a fireproof safe or a fireproof filing cabinet or something of the sort, and you put your original in there. And then you let a couple key people know where it is. And that's it. Oh, a common question that people ask is, do you need to let everyone know about your will or what's in your will? No, you don't. But it is important, in my opinion, that you let a couple of key people know. Because otherwise, how are they going to get the will in order to probate it if they don't know about it or know where it is, right? So that's estate planning in a nutshell. If you got comments or questions, please leave it. I'd love to hear them. I'd love to answer them. And for more, follow the Titus Law Firm. I'll see you next time.